Okay, good morning. Welcome to a session of the oral argument of the 5th DCA. We had a panel change. I am again Judge Lambert presiding, and to my right is Judge Harris, and to my left is Judge Edwards. This is our 11 o'clock case number 1919, Apex Roofing and Restoration, LLC, as assignee of James Derrick versus State Farm Florida Insurance Company. All right, counsel, each side will have 20 minutes. I have 5 minutes reserved for the appellant for rebuttal unless you tell me otherwise. And if you have any phones or other electronic devices, please put them in the off or mute mode so that they don't inadvertently go off and distract your opposing counsel or yourself or the panel. That being said, if you're ready to go, counsel, you can proceed.
Yes, I am. Thank you, Your Honor. I'm Gray Proctor for the appellant, Apex Roofing and Restoration. I would reserve 5 minutes for rebuttal, as you said.
Okay.
So we're here today on two questions. The first question is whether 624.155 tolls the statutory cure period until the amount of damages have been liquidated and the contractual loss payment provision is active. 624.155 doesn't toll. Then the second question we're here on today is whether the CR...
Or the appraisal tolls the running of that until the appraisal is done.
Well, that's correct, Your Honor. That's State Farm's argument, is that the appraisal tolls it. But we have
That's
to
what
look
the judge found as the first ground for the denial, for the granting of the summary judgment, saying it tolls it, and then the bad faith was cured once they timely paid the appraisal amount, even though the 60 days under the CRN had run.
And that's correct, Your Honor. My point is to focus us to the language of the statute, right? Because in Florida, a first-party bad faith claim is completely a creature of statute. And 624.155 doesn't say anything about tolling at all, or at least this version, the version that applies to our dispute today. What the statute does is it sets a condition precedent for filing a bad faith claim. You have to give the insurance company 60 days notice of the allegations. But it doesn't set any conditions precedent to the CRN itself, and it certainly doesn't direct anyone to look to the insurance contract to see when payment becomes due. That really ought to be the end of the inquiry because, again, we need to look to the statute here. This isn't a common law cause of action. But as Your Honor has said, State Farm's argument is really that the contract controls over the statute. State Farm relies on the loss payment clause, which provides that after the amount due is liquidated in one of three ways, the insurance company has a certain amount of time to pay the award. And I'll summarize their argument here. No amount was due or owing during the 60-day period because the parties had not agreed to the amount of the loss, there was no judgment, and there was no appraisal award filed with State Farm. And so that, of course, goes straight to the loss payment clause. And what State Farm argues is that the cure period must have been tolled until an additional amount was actually due under the policy. State Farm is wrong for a couple of reasons, and I'd like to start with the contract itself. The loss payment clause doesn't create the obligation. The coverage creates the obligation, and the obligation to pay arises as soon as the loss occurs. The loss payment clause settles the timing of the payment and gives additional time to pay after the amount of damages have been liquidated. State Farm's interpretation of the loss payment clause is inconsistent with two other areas of law. Number one, if State Farm's interpretation was correct, I don't think we could have an AOB here because there would be nothing to be assigned because there would be no obligation. That ship has sailed. The AOB litigation was several years ago, but that point is still true today. Number two, to read the to read the loss payment clause the way State Farm does, I don't see how you could ever sue for breach of contract or get a judgment. If no amount is due until the amount is settled through the loss payment clause, and if there's no appraisal and there's no agreement, how can you sue and establish a breach of contract and get a judgment under the loss payment clause? So I just don't think the contract should be interpreted that way. Number two, I think State Farm is wrong about the role of the appraisal process. The statutory duties aren't implicated in appraisal. It doesn't overlap with the statutory duties. There's no, regarding appraisal, there's no duty to use good faith or to investigate. Under the contract, if a bad actor wanted to, the insurance company could just invoke appraisal in every case as a substitute for doing its own investigation. That's okay under the contract. That's not permissible under the statute, and this is back to the Vest case. The statute imposes on the insurance company a duty to use its expertise and perform an independent investigation and pay what's owed. And finally, I'd say here that State Farm is wrong as to the statute. Again, just as a textual matter, the version that applies to this dispute doesn't say anything about tolling, and it doesn't direct us to look for conditions precedent for payment under the clause. Aside from this purely textual reason, there's a purposive reason not to go with State Farm's interpretation. And that's that, as was alleged in the CRN here, the appraisal process can actually be a tool of bad faith. This is not to point any fingers at State Farm or any other specific insurer, but we can imagine an insurance company, the proverbial bad actor, who, rather than doing a good investigation, hires somebody off the street, says, go take a look at the house, and with no guidance, tell me what you think the claim is worth. And then the insurance company could underpay that as well. In terms of the breach of contract, that's okay. Appraisal can cure the breach of contract, and it doesn't matter under the contract that the insurance company has underpaid claims, that it has played the odds, that insurers just won't pursue it any further. It doesn't matter under the contract that the insurance company has shifted part of its investigation cost to the insured through the appraisal mechanism. But State Farm wants to read it to go further. State Farm also wants to be insulated from the consequences of the bad faith, and not just the breach of contract. Again, I'm not saying
the bad faith statute was amended, I think, shortly after all the relevant facts here were developed, to basically say if the appraisal process is started, then you can't file a CRN for 60 days, right?
Yes, Your Honor, that's
okay,
correct.
and that almost is kind of a response to our court's decision as Landers versus State Farm, where we said that there was nothing that prevents you from filing a CRN during the appraisal. So, but you know, some of our colleagues and other courts have pointed out that the legislature could have readily amended the statute to say, and oh, by the way, anytime the appraisal process is issued, even if there was a CRN that had been filed, like the timing is in your case, they could have put that in the statute and said, oh, by the way, the initiation of the appraisal process tolls the running of the CRN until the 60 days until the appraisal process is completed, but they haven't done that as of yet. I don't know if they did that in their recent session or not, but as of yet, they hadn't, pertaining to us, they hadn't done it. So that seems to be some suggestion that we shouldn't read the 60-day tolling as requested by State Farm into the statute here presently.
Well, I think Your Honor is correct. And I believe it was in the Fortune case, but you know, the fact that it was amended is a pretty strong indicator that there wasn't any tolling before. Here we're in a slightly different factual posture because the appraisal was evoked as a response to the CRN. And I think Your Honor is right. Even if that statute, even if the amendments were to be applied retroactively, they don't address the situation that we have here. Right,
because I mean, one of the judges, I think it's Klingsmith, talks about it. You know,
It's turning into a rush to the mailbox, but that being said, that's up for the legislature to remedy, not us.
And I don't think that there's anything in the Senate Bill 2D or the new 4 that was signed into law. I don't think they fixed it this time.
It doesn't matter at this point, because we're past
Well,
that.
that's true, Your Honor. So aside from these statutory factors, State Farm's position is also inconsistent with every decided case so far. And I think the way to approach is just to walk back quickly through these 4 most recent cases. First, we have Zaleski, which is obviously the most factually similar. In Zaleski, we have the appraisal being requested in response to the CRN notice. Same thing that we have here. Now, obviously, I'd love to see this court write an opinion that looks a lot like Zaleski, and I hope the court is persuaded by Zaleski. But what I'd like to highlight today is that State Farm hasn't really distinguished Zaleski from what's going on here. What was raised in the briefs is that because the argument to the Zaleski court was framed in terms of tolling, and the Zaleski court talks in terms of cure, that the argument wasn't really decided. I don't think that's correct for 2 reasons. Number one, tolling and cure are really 2 ways to say the same thing. You can say, was the 60-day period tolled, or can you say, did a payment on a certain date cure the violation in the CRN? But it's really 2 sides of the same coin. And then, of course, the Zaleski court mentions tolling a couple of times. It refers to the 60-day period being tolled, and it says that it disagrees with the interpretation that 624.155 was tolled until the lost payment clause was satisfied. Of course, Zaleski's not binding on this court, but in terms of distinguishing it, I don't think that State Farm has done this.
Well, before you run out of time, let's go to the second grounds for the summary judgment being granted, as the judge specifically found that there was not sufficient factual specificity under 624.155 regarding the facts and circumstances giving rise to the violation. So if we look at 3B of that statute, there's 5 enumerated things that must be stated with specificity. The judge only focused on B2, the facts and circumstances giving rise to the violation. So that's the only thing that's before us.
Yes, Your Honor.
I would see it. So
Anything to do with the
I'm not
stat-
asking for debate about that.
Okay.
So why don't you tell us why you think the trial judge erred as a matter of law in determining that you have not provided sufficient specificity as to the facts and circumstances in your CRN?
Thank you, Your Honor. The point of the CRN notification is to enable the insurance company to investigate and to cure. So in terms of whether the insurance company can look at this and cure the alleged violation, the CRN asks for 5 specific things that are, the position that the insured takes is that if you do these 5 things, it's going to be cured. So that's there, and the out is there. And the 5 specific things are to pay the amount due under the policy, to pay interest. There are 2 other conditions that basically amount to act in good faith with us in the future. And the 5th one is to admit that misconduct has occurred. Now, the insurance company may not want to do that. I understand no settlement is usually going to involve that. But if the insurance company wants to cure, it can do the 5 things that are in there. In terms of it not being factually specific, I think we should start with the 3 grounds that are alleged in the complaint. And I know that the CRN itself does refer to more statutes, but by the time we get to the complaint, there are 3 grounds, and that's the violation of the duty to settle under 624.155 1B1. The material misrepresentations under 9541, and then adopting and implementing standards under 9541 1I3A. There's factual support for all of these three allegations in the CRN. The violation of the duty to settle comes from failing to pay the full value of the claim. And additionally, it's alleged that State Farm had an intent to induce an inadequate settlement and to use appraisal as a delay tactic. Material misrepresentation goes straight to the value of the claim as State Farm has offered. So I think that is also clear from the allegations in the CRN. And then in terms of adopting and implementing standards, until we can get discovery and get into the claims handling practice, we don't know a lot about that. The only thing we can do is allege that the standards were inadequate and point to the fact that the full value of the claim wasn't paid. And I think that should be enough at this stage of the inquiry. And so if there are no further questions, I'd reserve the remainder of my time.
Okay.
Thank you, Your Honor.
Yes, sir.
May it please the court?
Yes, sir.
Thank you, Your Honor. Paul Nettleton of Carlton Fields on behalf of the Appalachia State Farm Florida Insurance Company. Your Honor, we're asking the court to affirm the summary judgment for the two grounds ruled on by the trial court. And if I could quickly summarize them, then I'll address each of them in more detail. But first, it's our position that under the undisputed chronology of facts here, the events that occurred, that in order to give any meaning or effect to the notice and cure provisions of the statute as interpreted in the Tallet decision by the Supreme Court, the trial court properly ruled that that cure period has to be told until there's an appraisal award filed with State Farm. And the reason for that is because the appraisal award is, in the words of Tallet, a condition precedent to payment owed under the policy. And because State Farm paid it within 60 days, actually within 2 days of it being issued, we submit there's a cure. The second reason we submit the summary judgment should be affirmed is because the trial court properly ruled that the civil remedy notice was legally deficient under the statute. It's a statutory condition precedent. It's deficient not only in the facts and circumstances, but also...
That's all she said.
Well, Your Honor, I looked at the order. The only thing...
It's like I did in the first argument today. In this case, the CRN filed was conclusory statements that did not allege with any factual specificity as required by the statute. That comes right out of number 2.
Yes, Your Honor.
And so all the other 1, 3, 4, and 5 under 3B as to what the notice should be contained, or whether there's sufficient specificity under those, was not ruled on by the judge. So that would tend to be something that we wouldn't address here.
Well, let me just challenge that a little bit, Your Honor.
Okay, well, you should talk to the other two, because...
Thanks. What the court said, the CRN must comply with Florida Statute 624-155 and state with specificity the facts and circumstances giving rise. In this case, the CRN filed was conclusory statements, did not allege with any factual specificity as required by the statute. I think that can be interpreted as broader, and I say that because the Julian case was specifically raised with the trial court. It was filed before the hearing
But
and
that's not what
argued.
she said. That's not what she ruled. She didn't say, oh, by the way, it's defective under all 5 of these things. I mean, it talks about state with specificity the following information, and number 2, the facts and circumstances. So the 2 sentences that you read, state with specificity facts and circumstances giving rise to the violation, that's a number 1, and then number 2, her findings, its conclusory did not allege any factual specificity as required by the statute. So I guess, you certainly can be an advocate, but I don't know how else that we would say, oh, that meant
Your Honor. Well, I will certainly focus on that issue, but let me address the cure argument first. In Tallet versus Aetna, the Supreme Court address the import of the language of the notice and cure provisions of the statute. And I think it's also important to remember that the reason it addressed it is because the statute's ambiguous. The 11th Circuit actually certified a question to the Supreme Court as to what this provision meant in terms of pay the damages in order to cure. And it was in that context that the court addressed this. And we submit that the cure period in the statute cannot be divorced from the terms and conditions of the policy or as the court defined it, the contractual amount due. And the plaintiff's argument here is that you do have to divorce it, and they're completely separate, and it doesn't matter what the terms and conditions of the contract say, and you just have to pay something within 60 days, even if under the contract nothing's owed during that time period. And that would effectively nullify the contract provisions.
Didn't we talk about that in Landers, though?
No, Your Honor.
In Landers, State Farm moved for summary judgment. They asserted that when Landers filed the CRN, there was no contractual amount due and no damages owed under the contract because a condition proceeding to payment determining the amount of loss through appraisal had not been fulfilled. Therefore, the CRN was not valid. Landers had no claim. That was State Farm's argument, according to what Judge Cohen wrote a couple of years ago for us. And this is obviously after Tallet, so why wouldn't we just say, well, Tallet controls all of this, and we were wrong, and the second and the fourth in their cases?
No, I think we're talking about different issues, Your Honor. In Landers, as Your Honor just read, what State Farm was arguing there, and it's repeated a half dozen times in the opinion, is that the CRN filed before the appraisal award was invalid, was void, was a legal nullity. That's not what we're arguing here. This is a valid CRN. It's invalid for a different reason, but not because it was filed before the civil remedy notice, which is what the court decided in Landers. In this case, Your Honor, the Florida Supreme Court has been very careful to not adopt a construction of the cure provision that disassociates it with the terms and conditions of the policy, and in fact ties it directly to it. In Tallet and in Vest, they both address this issue. In Tallet, the court held that this language in the provision that says you can cure by paying damages, what that means is pay the contractual amount due. And then the court went on and defined what it meant by the contractual amount due. And it said that means, and I quote, the amount owed pursuant to the express terms and conditions of the policy after all of the conditions precedent of the insurance policy in respect to payment are fulfilled. The cure payment is directly tied to the terms and conditions of the policy. Court went on to say there's no remedy under the statute until the insurance company has an opportunity to cure by making this payment. In Vest versus Travelers, the court addressed the cure provision again. And it does admittedly say if payment is owed, an insurer can cure by paying that within 60 days of the CRN. But the big caveat there is if payment is owed. The court goes on to say in Vest, what is owed for purposes of this cure payment is governed, and I'm quoting again, is governed by whether all conditions precedent for payment contained within the policy have been met. Here, express terms and conditions of the policy, the loss payment condition, condition 8 in the policy, specifically provides that where the parties do not agree on the amount of the loss and appraisals invoked to make that determination, that the filing of the appraisal award with State Farm is a condition precedent. Nothing is owed before that.
Let me make sure I understand how this could work then. So you have a covered loss to the roof. The homeowner makes the claim, uses the proper form, says, we've been damaged, $30,000 roof. State Farm goes out and looks at it and offers them $5. And they got a big hole in the roof, and they can't afford to get this fixed because they don't have the money to get it fixed. And so they're back and forth with State Farm. Finally, they retain counsel who files a CRN. Then the CRN is on day 59. State Farm invokes the appraisal thing, and then you go through the appraisal, and several months later, the appraisal award comes back at $50,000, and you pay the $50,000 within 60 days. If I'm understanding your argument, and correct me if I'm wrong, you would say, you know what, that bad faith is out the window, you can't bring a bad faith claim. Am I accurate with that?
I think that's an extreme example,
Well, I
Your
know
Honor,
that, but I mean, that's the point, is
I,
that, you
I
know,
think, yeah, the numbers and the timing and so forth, that would be correct, and here's why.
but that's bad. All right, so you've acted, but you had a valid claim that you know is worth more than $5, and for whatever reason, State Farm took that position. I'm not saying you or State, but I mean, if
Understood.
it makes you happy, Allstate takes that position in my hypothetical and does that. And so if your position seems to be that if I file a CRN, because I'm getting nowhere with the Allstate, that on day 59, when the same identical provision, the Allstate policy, the appraisal provision is invoked, and then everything stops or is told, according to this judge here, then 6 months later, when the appraisal process is done, and then you guys get the 50 grand, which is consistent with what was asked for long ago, and you pay that on the day 59 of the post-appraisal award, that as a matter of law, there's no bad faith because you've now cured it timely.
Not no bad faith, but there has been a cure. What you've been talking about
But
is
isn't there a
bad
bad faith claim? Isn't there a bad faith claim that they could lawfully pursue there?
Not if it's been cured, and that's the whole point
I
of a
mean,
cure.
so basically, you instead of saying yes, but that's what you agree, under my scenario, that's what happens, even if it's egregious that they should, $5 grand was a ludicrous offer, that's a bad faith offer, or certainly a trier of fact could construe that to be bad faith, that you end up owing $50,000, you offer $5, not $5 grand, $5, Allstate, not you. And then down the road, I'm a former trial judge. I know whenever I gave hypotheticals, the first thing is, that's not the facts of our case, Judge. I know it. If I'm making up the hypothetical, it means it's not the facts of the case. But my point being is, you seem to say that before day 60 ran on the CRN, once I invoke the appraisal, the meter stops. Then we have to wait for the appraisal to be done, and then I pay the appraisal within the time frame allotted under the contract, and I pay the full amount. Then there is no more bad faith claim that can be asserted. Or if they do file one, then you could file your motion for summary judgment dismissal saying, hey, pal, it was told, we got the appraisal, I paid the appraisal, what are you complaining about? Isn't that your argument here today?
I believe you are correct, Your Honor.
Okay.
And
I
here's
just wanna make sure I was clear.
But why I think it's an unfair question, though. First of all, forget the facts of this case, which are the complete opposite of that.
It may be no bad faith today. I get, down the road, this may be no bad faith claim at all. You were $2 grand off on the appraisal. I get all that, but that's not what we're here about.
Policyholder can always demand appraisal themselves if they think it's an unfair offer and proceed with appraisal. The point is, Your Honor, all you're describing is bad faith, right? And the question here is not, did State Farm act in bad faith? That's later down the road if the court reverses. What the issue here is, assuming there were bad faith, assuming there were a violation of the statute, as you've posited, how do you cure it? And that's what Zaleski didn't answer. That's what Fortune didn't answer. And the way you cure it was answered in Talent by the Supreme Court.
The issue here is the judge says it's told. So under my hypothetical with Allstate, not you or State Farm, with Allstate, the meter stopped. So the CRN never kicks in under your argument because the meter stops once Allstate made the appraisal request, and then when they pay it 6 months down the road, in my hypothetical for the full amount that was demanded a year and a half earlier by the homeowner, that basically means there is no bad faith
No
claim.
claim.
Right.
Correct, Your Honor.
That's
It's
the
been
argument.
cured.
That's the argument that was brought below, and that you're arguing here. And you're saying Talent says that. Am I summarizing any of that incorrectly?
Well, I think the hypothetical is incorrect, but I agree with Your Honor.
How can his hypothetical be
Yeah,
incorrect when he's making it up? Come on
Honest to
now.
God, honestly, I've done this for 22 plus years, and I tell people I'm making a hypothetical because when we do that as judges, we're trying to make the point. We want to crystallize what is the actual
Understood.
argument being made. And so, yeah, if the appraisal came back $1 more than when you had offered, then yeah, I'd be looking at this guy saying, how's that bad faith? But I'm making the hypothetical because you're making a legal argument to here because we're talking about a legal issue on a summary judgment.
Understood, Your Honor.
Okay, well then, the
I
facts
agree
are the
with you.
same.
I agree with you, Your Honor. And the point, again, my point is, what you're discussing is, assuming there's bad faith, assuming there's a violation of the statute, how do you cure it? That's the question
I know,
here.
and you're saying that's a cure. You're saying it's cured by those facts that I've laid out in my hypothetical here,
the bad faith is cured by paying that appraisal at the time that, in the chronology that I've outlined.
Right, because the Supreme Court in Talbot said that the way you
Facts are so
cure,
different. You don't get into the period of cure there because the CRN was served after payment was made. I mean, that's not this case.
understood.
At that
Factually, it's
point-
not the same case, I
Right,
agree.
And if that, talk about an unfair hypothetical, comparing talent to this case is unfair.
I'm
I
not
mean, it's-
comparing talent, Your Honor.
Well, but-
Well, the judge
The
cited
judge
it.
relied on talent, you argued talent, or the trial lawyer argued talent, and the judge relied on talent, so please don't tell me you're not relying on talent.
I am absolutely relying on talent, Your Honor.
But, there, the only real bad faith at that point was payment. I mean, here, under Judge Lambert's hypothetical, and I guess under what the insured here is trying to, or Apex is trying to argue is, there's bad faith in adjusting. There's different ways to have bad faith. Bad faith in not paying, bad faith in not adjusting in good faith. So here, it seems to me, you go have your case, there is a case, there is a trial, whatever, and it's like, hey, we sent people out there who knew what they were doing, they acted in good faith, we came within $2,000 of what the appraisal was, that's not bad faith. That I get. To say that there's no opportunity to discuss that in terms of litigation because there's a tolling, I'm looking at 624-155, it's not there.
Well, Your Honor, again, I go back to Talbot, not the facts of Talbot, but to the holding in Talbot, which was defining what that language in the statute means, that the way you cure is paying the damages. That was the language, that's the language still today. It hasn't changed since Talbot interpreted that statute. And what Talbot said was, what that means is pay the contractual amount due, and the contractual amount due is the amount due after all conditions preceding in the policy have been fulfilled. So how do you separate that out? How do you cure if there's nothing owed at the time the CRN's filed or during the 60 days after? There's no opportunity to cure because there's nothing owed during that period. And that's why I'm saying the only way you can give effect to the meaning of the cure as interpreted in Talbot.
I mean, you don't know what is owed during that 60-day time, during the time appraisal. They're going to tell you if anything is owed or not. They don't, it's not nothing is ever owed. It's you don't know how much is owed or if anything is owed.
Well, and I would submit, Your Honor, nothing is owed because the condition preceding to the amount owed is the filing of the appraisal award with State Farm. And that doesn't occur within the 60 days, therefore nothing is owed within those 60 days. How does the insurance company cure? It can't in that scenario. And the Supreme Court said you got to have an ability to cure before there's a remedy available.
It could have cured. I mean, let's say you had made your second payment. Let's say the second payment was $5,000 more than State Farm had paid. And Mr. Insured or Mr. S&E of Insured says, I still don't want that. And you guys then invoke the appraisal, and the appraisal comes back in an award that's actually less than what you guys paid. So, but they still decide to pursue the bad faith claim. I think then you'd have a better argument to say, we've already paid you more than we ever owed you, so how could we possibly be in bad faith under any scenario? And I think that would be, because you can invoke the appraisal process doesn't mean you can't independently resolve the case outside the appraisal process or during the appraisal process. And whether you acted in bad faith or not, you're asking us to decide, or the trial judge is deciding as a matter of law that you didn't. And that's, I think, what certainly at least two of us are having a hard time in our vocalization.
What if appraisal
Judge
wasn't
Harris
invoked
may
by
be
either
thinking this
side
anyway.
and you were instead going forward on a breach of contract case? I mean, neither one of you wants to mediate, neither one of you wants an appraisal, you go on. So then nothing's due until final judgment and I guess then also the conclusion of appeal?
No, Your Honor. I think that's a red herring that was raised by counsel. That hasn't been argued in the case before, but the fact that the judgment provision and the lost payment provision, that's for unique circumstances. For instance, there may not be any question about the amount owed. It could be a question of whether the person making the claims is insured, whether it's within the policy period, other kind of coverage issues that would be subject to a declaratory judgment action. In those circumstances, that's where the judgment language and the lost payment provision comes in. We're not dealing with that in this particular case. I see I'm running out of time, so I would like to jump over to the CRN issue real quick. And I'll skip over Julian and go right to this court's decision in Lane versus Westfield, which addresses the facts and circumstances aspect of a CRN. And in that case, this court held that where the facts and circumstances are too vague to give the insurer notice of what it can do to cure, it fails to comply with the statutory requirement of specificity. And that's precisely the situation we have here. It's a lengthy CRN, very prolix, I would submit, but prolixity is no substitute for the specificity that's required. And if you look at this as we presented to the trial court, these are all boilerplate, conclusory allegations that plaintiff's trial counsel puts in every CRN against every insurance company. Everything counsel just read from that CRN, if you look at the other CRNs that we put in the record at 215 to 268, just a sampling, they all have the exact same language. It's verbatim except for the name of the insurance company. There were no facts and circumstances alleged.
In Zaleski, I know a case that you're not fond of, they also address the sufficiency of the specificity of the facts and circumstances giving rise to the violations in the CRN in that case. And reading that, which the fourth DCA found to be sufficiently alleged, seemed to be similar to the facts and circumstances alleged in our case. Maybe not verbatim, but similar. So I'm curious as to why that, again, for your benefit, we all understand that Zaleski is not binding upon us. They're our sister court, and they can be persuasive or not, depending on what we see. But
I think it's very hard to compare the CRN in Zaleski to the one here. This one is more comparable, by the way, to Julian, but I won't go into all of that.
well, the only issue with Julian is I'm saying that the judge just said this one subsection of that statute is what she found lacked the specificity.
Understood,
I'm
Your
not discounting Julian per se. I'm just saying we ought to address whether reversible error was committed by the trial judge here on the specific ground in which she entered the summary judgment, not on other things listed in the statute that she did not specifically address.
And addressing that, Your Honor, where in the facts and circumstances are there any facts alleged with regard to this particular claim that support the 9 statutory violations alleged in there, which include things such as making misrepresentations, not failing to explain coverage decisions and payments being made? And where are the facts that say failing to respond to communications? They're not there, Your Honor. Those are the statutory violations alleged. Where are the misrepresentations? If they had laid out something they said was a misrepresentation, I don't think there's anything there. State Farm could have addressed that. If they had pointed out somewhere where there was no communication in response to a communication on, we could have pointed out, no, we did communicate to it or respond to it at that point. If they wanted to point out, oh, you didn't give us an explanation for this payment or why you made this particular claim decision, none of that's in there, Your Honor. If they had done that, then we could have addressed it. I don't think there's any facts that would support it.
Didn't you all respond to you all responded to the CRN, and you didn't question the specificity of it in your response, did you?
No, I disagree with that, Your Honor. I think the first response to it did specifically raise concerns with the specificity and asked, because it was so lacking in specificity, that additional details be provided as to facts as well as documents to support, because State Farm wanted to address whatever they thought was going wrong. The second response said the same thing and said, by the way, you didn't give us anything in response to our first response.
Okay, counsel, you're past your time. I'll let you wrap up for 30 seconds if you want to.
Okay, and just in terms of the waiver argument that you're, I think, referring to here, Your Honor, that was never raised until the
I get
reply
that.
brief here.
I agree with you.
So we'd ask that the court affirm for the reasons stated as well as in the briefs. Thank you, Your Honor.
Thank you. Okay. Mr. Proctor, you have 4:52 in rebuttal if you would like to use that.
Hopefully today's not a day where I should have just sat down. I would like to use at least some of it.
However you want to use your 4:52, sitting there talking, it's up to you.
Well, I do want to come back and just address a couple of things quickly. Number one, in Talat, to the
But
extent...
what about his argument? Well, that's what you're opposing, that basically, and I know it's not you, but I guess it's Mr. Kaminsky, that basically he has the same CRNs in all cases, so how can there be some factual specificity unless he miraculously has the same issue on every one of his cases?
Well, that's one take on it. I mean, it could be a
Okay,
matter
I know it's
that
my
this is-
hypothetical, but go ahead. Everybody hates my hypothetical today, but go ahead.
Well, hopefully we can get some discovery and we can find out, right? But it may just be a matter that this happens over and over. But here, the factual specificity, at least, I think the court still has to reverse, because at the very least, with regard to the violation of 624.1551B1, not settling in good faith, that's in the CRN, that's in the complaint, and I think it is more than adequately alleged here.
Okay, but that's not what the judge found as being wrong. The judge basically, as I'm reading it, is the B2. There are not sufficient facts alleged with specificity as to how.
Oh, well, and I'm sorry, I'm not referring, Your Honor's correct, the only thing that's at issue here is factual specificity. 1B1 is the violation of not attempting to settle in good faith, and so that's in the complaint, and that's in
She
the
didn't find that. She didn't say that you didn't. She didn't find that the CRN was lacking there, right?
She didn't find that the CRN was lacking with respect to any of the concrete allegations, I believe.
Well, she says
It's conclusory and...
conclusory and did not allege with any factual specificity as required by the statute, and the statute requires factual specificity as to the violation.
Maybe you want to point out the factual specificity in the CRN to us?
The factual specificity in the CRN, Your Honor, thank you very much. This is what's clearly alleged. It's clearly alleged that State Farm underpaid the claim by $35,000-odd. It's clearly alleged that...
I know. I mean, for example, State Farm sent somebody out here to examine the roof, and they've never been on a roof in their life. Or they sat at the One Horse Saloon next door here for 3 hours before they went over there, and therefore they couldn't even find the place. I mean, I don't know that that's required. I'm just saying, for example, that's in saying you didn't do a good job. I think the issue is, well, what didn't they do? Is this factual specificity that perhaps the statute is requiring that your opponent is contending was lacking and the trial judge was correct in her ruling?
Well, whatever the factual specificity is that the statute requires, and I don't think there's a lot on that anywhere. We have Lane responding with accusations doesn't meet it, and I agree, responding with accusations doesn't really tell us anything. But the statute shouldn't require a level of specificity that you can't get to without discovery. There's no way, we're talking about State Farm's intent, and it's the intent of its agents and its corporate representatives. There's no way to allege the specific facts regarding State Farm's intent. There's no way to do it. That can only be alleged generally. And the facts that are alleged would be, that are appropriate to be alleged in a CRN would be ultimate facts, as Judge Padovano in his treatise on appellate law and some other places have said, that what needs to be alleged are the ultimate facts, and that's how the law applies to the facts in this case. It doesn't require pleading evidentiary facts and setting forth everything you expect to discover and everything you expect to prove at trial. If that was the case, none of these could ever go
Well,
forward.
I know, but I mean, we've been gigging your opponent here about the statute doesn't talk about tolling. I mean, the legislature said specificity, and it seems like you're saying, well, how can we do that, so we shouldn't have to. Well, the legislature seemed to say otherwise. So.
Well, good for the goose, I'd say. But the violation of not attempting to settle in good faith, that's alleged in the complaint, that's in the CRN, and I think the facts are sufficient to support that. State Farm underpaid the claim. They should have known that it was underpaying based on the estimate. State Farm delayed.
Well, let me say, when you got up here, you wanted to talk about something else before I diverted you. So I gave your opponent an extra minute or two, so go ahead.
Well, thank you, Your Honor. In terms of Talat, the only ambiguity that the Talat court identifies doesn't have anything to do with the issue here. Talat, the ambiguity was how much has to be paid in damages. All of the extra contractual damages sought are just the breach damages. So Talat isn't a door that lets the court go in and use the tools of construction because the statute is ambiguous. I'd also say that there's, Your Honor's hit on it a little bit, the consequences of adopting the lost payment clause as what the condition precedent to filing a CRN. There's no principled basis for saying, if it's appraisal today, then in other cases, you can't file a CRN until the end of the trial, and that's a problem. And finally, you talked about cure. How do you cure? Well, the cure is not a get out of a lawsuit card. You cure, the statutory cure period lets you cure a violation by exercising good faith. If you haven't looked at it, if you haven't investigated it, you have an opportunity to do that, and that's the cure. The cure does not equal keeping the policyholder from having its day in court. So unless there are any more questions.
Okay, thank you. All right, we'll stand adjourned. Thank you.